strictly by the rules. Fortunately, we have a timekeeper who will keep reminding us about how much time we've spent in our submissions, which will require that you make it known to us that Council 1 will do 10 minutes or 2 minutes or 5 minutes, and then one will come to rejoin if you're for the appellant. But for the respondents, they'll do their straight 30 minutes. But for the appellants, you need to reserve some time for a rejoinder, if any. We will be guided by the rules availed to us, and I think we're ready to commence.
May it please this Honorable Court, my name is Akankwasa Isabel, together with my land counsels, Miss Evelyn Semere and Mr. Gabriel Ejai. We are counsel for the appellant, Miss Rita Enzoma. We shall use up 30 minutes of this Honorable Court's time, and I'll use up 10 minutes to handle jurisdiction and issue 1. The second speaker will use 7 minutes, and the third speaker, Mr. Gabriel Ejai, will use 7 minutes. We reserve 2 minutes for rebuttal. I beg to proceed. The matter.
Do you want to allow opposite counsel to introduce the team?
Much obliged.
Respondents.
May it please this Honorable Court, I am Ochuo John Isaac.
May it please this Honorable Court, I am Counsel Amanya Belinda.
May it please this Honorable Court, I'm Counsel Napale Hotel.
Much obliged, my lord. The matter before us, in the trial decision, there's not only a grave infringement of the human rights, of the women's human rights, but also a miscarriage of justice that held and upheld the patriarchal sentiments of systematic discrimination of women. I will address jurisdiction. The jurisdiction of this Honorable Court is a creature of statute stated in Article 134, Clause 2 of the Constitution of the Republic of Dakala. Rule 1 and Rule 2 of the Judicature Court of Appeal Procedure Rules is to the effect that matters from High Court arising on appeal will be handled by the Court of Appeal. Section 30 of the same rules is to the effect that this Honorable Court has the duty to reevaluate the evidence before it and come to its own decision. This is reinstated in Father Nasensio Begumisa versus Eric Tibebaga, a civil appeal case of 1997. To handle issue 1, that the trial court's decision not only infringed on the rights of equality, freedom from discrimination, and property rights of the appellant. I will discuss it under two heads of argument. One, that the property in question is matrimonial property, and secondly, that despite the property in question being customary land, the appellant still has equal rights to it as the respondent, Mr. Robert Okoye. To discuss matrimonial property, legislation in the Republic of Dakala has not defined matrimonial property. However, case law has defined the same to give us a three-part test, and I seek to persuade this court using 2 cases. One, which is Hope Rabinumi. I seek to persuade this court, pardon me, my lord, using 2 cases, which is Hope Rabinumi versus Hope Bahimbisomwe versus Rabinumi versus Bahimbisomwe, which is a civil appeal case that gives us the test that matrimonial property is property that the couple chooses to call home. And I seek to also use a civil appeal case of Chintu versus Chintu that expands matrimonial property to include land that the husband can hold in trust for the clan. In the facts before us, on paragraph 10, it is clear in the three-part test that they called it home, that the couple chooses to call it home, they jointly contributed to it, and that it was held in trust for the clan the test is fulfilled in the facts before us. Paragraph 10 is the effect that the couple called it home. Paragraph 11 and paragraph 3 is that Mr. Robert Okoy held this land in trust for the Tonga clan. We therefore pray to this honorable court that it will find in due cognizance that the property in question is that raises to the yardstick of matrimonial property and will be duly divided as discussed in Rabinumi versus Bahimbisomwe. I seek that this honorable court is persuaded by the Palgrave Handbook on African Women's Studies that discusses the systematic patriarchal tendencies that have been upheld in not only the laws, but also the customs. The normative test of the right of equality is discussed by the United Nations Committee, that is the effect that there should be full participation, inclusion, consideration, and prohibition of any discrimination against women. I seek this honorable court to be persuaded by the Special Rapporteur on the Rights of Women in Africa, resolution number 262, that is done by the African Commission, that discusses the hierarchy and the special needs of women at divorce. In the matter before us, it is clear that the appellant is not educated. The appellant, inter alia, has been violated. There has been domestic violence. She had to actually seek for medical help. Most of the appellant is not doing economically well. When you look at Miss Rita Nzoma, she actually seeks for pro bono legal aid. She does not have the financial capacity to represent herself in court. Justice is a right of every human being, and it is clear that her right is being infringed upon. We pray to this honorable court that it will find in the publication by FIDA on Chibuku district in Uganda, a publication held in 2018, it discusses the persistent violation of women's rights. When we look at the trial court's decision, it granted her 20% of the value. I would like to move on to my second head of argument that discusses customary land. The land in question, we do not seek to contest that the land in question is customary land. However, we assert to this honorable court using the case of Lucy Oma versus Chidega Moses, where Justice Mubiru on page 12 discusses the usufructory rights that arise from commonly held land. We therefore discuss that commonly held land causes common property, and therefore leads to usufructory rights. The facts before us, yes, my lord.
Is your argument that usufructory rights also provide or is extended to ownership right?
Much obliged, my lord.
In relation to the case at hand and appeal, because your argument is that, as we think, is the user right seems to be connected to ownership, and so the same should be available for shares, patrimonial property. Is that your argument?
No, my lord, much obliged. I actually seek to assert that the trial court's judgment found that it could not give her a larger percentage of the land in question because it was customarily held. Justice Mubiru discusses that usufructory rights can arise from customary land, and those usufructory rights, she has the same rights as her husband, who is the respondent in this matter. She has the same rights over the land. When we look at the special report here, my lords, I pray that it recognizes that...
Counsel
yes,
Isabel, I just wanted to confirm, are you still discussing issue 1?
Much obliged, my lord. Issue 1 was to the effect of matrimonial property, and I've ended it giving the three-part test to this honorable court. And now I discuss issue 2, which is the effect that customary land, even though the land in question is customary land, she still has usufructory rights to it, and therefore we pray to this honorable court that it will grant her the same. Much obliged, my lord. So when we look at the Palgrave report here on the rights of women, it reemphasizes the vulnerable status of women. The vulnerable status of women, and the appellant is reaches the test and the yardstick of vulnerable people in the Republic of Dakala. She's not educated. In paragraph 10, when she goes back to her mother to actually seek for redress from the violence in her marriage, her mother tells her that she cannot actually get any property because the customs of Tonga are to the effect that women cannot own any property. We look at the fact that she is unemployed. She has invested 16 years of her life she has invested 16 years of her life to till this land, as discussed in paragraph 11, to actually be able to manage the land and invest. We look at the fact that the appellant seek to pray to this honorable court that 20% that was granted to my client does not amount and does not raise to the standard of what she actually deserves. The normative test of the right to equality is non-discrimination, prohibition, and guarantee of legal protection. She is actually not guaranteed. If it was not for Ngwange Women's Center, she would not actually appear before this honorable court. She is a vulnerable person, and therefore she needs her rights to land, and despite the fact that the land in question is customary land, we pray to this honorable court that it will uphold her usufructory rights, as there is a right to equality enshrined in the Constitution of the Republic of Dakala, and her rights from freedom of discrimination. The United Nations clearly say the United Nations Committee report on the African Charter of Human and People's Rights clearly discusses that there should not be systematic or any authority that infringes on our rights of equality. Women have the same access to land, and we pray that this honorable court will actually grant her economic right. When you look at the fact that she is a vulnerable person, women at divorce usually do not get the chance to remarry my lords. And therefore, even when she is left with no property,
To that effect?
much obliged, my lord, I meant that as persuasion. I do not have authority. However, I only seek to discuss that women become the marginalized. They are stripped away from their property. They don't have economic rights. The appellant is not even educated. Her mother clearly tells her, and the priest in paragraph 11, that she actually does not have rights. She cannot get land. She does not have an economic right. We need to reinstate her to be able to continue her life despite of the violence that occurred, her trauma, her emotional torture that she went through. Yes, my lord.
So by reinstatement, you mean she takes 100% of the land?
Much obliged, my lord. The appellant seek to assert that we request for 50% of the share or usufructory rights in the property in question. I realize that my time is fast spent, and we therefore pray as the appellant. I realize that my time is fast spent, and we therefore pray that the appellants will actually be granted usufructory rights on the same, that the property in question will raise to the standard of matrimonial property as referred to in the cases of Chintu versus Chintu and Hope, Rabinomi versus Bahimbisomwe, and court will take in due cognizance her rights and consider her as a vulnerable group of person, and therefore reinstate and set legal precedent in the Republic of Dakala for the 21 million women that are grappling with poverty. If I'm of no further indulgence to this court, I seek to cede the floor to the next speaker.
May it please this honorable court, Samara Evelyn Angela for the appellant, Rita Izoma, and in 7 minutes.
2 minutes? Just give us a minute, actually.
Much obliged, my lord. Much obliged, my lord. May it please this Honorable Court, Seminary Evelyn Angela for the appellant, Ms. Rita Izoma. And in 7 minutes, I address this Honorable Court on issue 2. Before I proceed, I seek to correct my colleague who said that she was arguing issue 2, but she made a mistake. She was arguing issue 1 under 2 heads of argument, and when you asked her, she was under her second head of argument. In Dakar and Africa, there's a visible systemic disregard for the rights of women, especially at the dissolution of marriages. These rights with regard to the distribution of matrimonial property. A rigid emphasis on documentation and procedure without context only entrenches these rights. My lords, issue 2 is to the effect that by giving the appellant only 20% of the value of the property on which the matrimonial home was situated, the trial court violated her rights to freedom on account that she did not produce documentary evidence to show her contribution to the matrimonial property. The trial court violated the appellant's rights to freedom from discrimination, equality at, during, and upon the dissolution of the marriage, and her rights to property, all enshrined under Articles 21, 31, and 26 of the Constitution of the Republic of Dakar, respectively, in conjunction with international instruments and regional instruments, and my emphasis will be on the Convention on the Elimination of all forms of discrimination against women, and the Maputo Protocol on the rights and welfare of women in Africa. Under issue 2, my lords, I seek to proceed under 2 heads of argument. First, that there is no need for the appellant to produce documentary evidence to show her contribution to the matrimonial property. And secondly, by imposing such a requirement, the trial court violated her rights as stated. May it please this honorable court, I seek to proceed under my first head of argument. Article 126(2)(e) of the Constitution of the Republic of Dakar is to the effect that in the dispensation of substantive justice, trial courts have a duty to do this without undue regard to technicalities. My lords, while the trial court was distributing the property to which the parties were entitled on the dissolution of the marriage, the trial court demanded for documentary evidence from the appellant. This points at the disregard, the blatant disregard of the appellant's contribution to this property, because first of all, it is non-monetary contribution that manifests in the form of unpaid care work, and this is manifested in the facts on page 5, paragraph 11, where the appellant engaged in tilling the land on the vanilla farm from which the family derived their sustenance, and at the same time, she engaged in unpaid care work, looking after the respondent, their children, and also cooking for the farmhands that worked on the vanilla farm. My lords, I would like to draw this court's attention to the fact that the appellant is living in a country of Dakar, which is dominated by the informal sector. We see that out of 55 million people in the Republic of Dakar, 44 million of these are working in the informal sector. That is 80% of the population in the informal sector. The appellant is no exception to these statistics, because in the facts on page 6, paragraph 12, we see that the appellant has no formal education. She's only limited to a primary education, and she's limited to the informal sector, therefore, and she cannot pursue any other form of employment but informal employment. My lords, the informal sector is dominated by informal transactions that largely do not involve exchange of receipts, and it was in the circumstances before this honorable court and the trial court, it was practically impossible for the appellant to prove her contribution to the property on which the matrimonial home was situated using documentary evidence. It is with that we pray that the trial court, by imposing such a requirement.
Counsel Isabel, so are you averring that the appellant was actually making a monetary contribution by virtue of employment in the informal agricultural sector?
No, my lords. My averment is that the contribution of the appellant was, first of all, non-monetary, and even where she incurred a few family expenses, it is practically impossible for her to keep receipts for basic family expenses over a period of 16 years. Much obliged.
To buttress that position,
What position, my lord?
do you have the authority to say that even without documentation, it's still okay to
Yes.
prove contribution?
Yes, my lords. I am under the Court of Appeal of the Republic of Uganda in the case of Ambayo versus Aserewa stated that where it is practically impossible to prove contribution to property to which the parties are entitled upon the dissolution of the marriage, courts may rely on the presumption of equal spousal contribution and assess and take cognizance of the contributions of the spouses to matrimonial property. Under the Convention on Elimination of All Forms of Discrimination Against Women, Article 16 emphasizes equal rights of men and women to property upon the dissolution of marriages. And under this, General Comment number 29 on this article stresses that women contribute to development of families and the welfare of families in the form of unpaid care work.
Council, the Republic of Dakar being a dual state, how binding is the Convention on the Elimination on All Forms of Discrimination Against Women to this court and the general comment you just cited?
Much obliged, my lords. The Convention on Elimination of All Forms of Discrimination, as you have mentioned, Dakar is a dual state and party to this statute. The statute, the international instrument, the CEDAW, gives state obligations for state parties to put into place to realize the achievement of these rights.
Has the Republic of Dakar domesticated the Convention on the Elimination of All Forms of Discrimination Against Women?
Yes, my lord. It has domesticated this law, and this is stated in the facts on page 2, paragraph 7. Much obliged, my lords. We therefore further to describe non-monetary contribution. It was stated in a World Bank report on gender divide and gender disparities in the distribution of matrimonial property in 2024, that non-monetary contribution in the form of unpaid care manifests in the form of the work that we see the appellant engaging in on page 5, paragraph 11. It is therefore our prayer, my lords, that this trial court re-evaluates the evidence presented to it by the parties, the largely oral evidence presented to it by the parties, pursuant to the Court of Appeal to the Judicature Court of Appeal rules, directions, and under Rule 30, which stipulates the duty of this court to evaluate the evidence and come to a conclusion that the appellant is entitled to 50% of the value of the property on which the matrimonial home was situated. My lordships, my time is fast. I realize that my time is almost fast spent, and I seek to wind up by praying that this court recognizes the appellant's non-monetary contribution and dismisses the trial court's requirement for her to produce documentary evidence, because that was a disregard of her non-monetary contribution, and it was having undue regard to technicalities in the dispensation of substantive justice. If I am of no further indulgence to this honorable court, I seek to cede the floor to the next speaker.
If it may please this honorable court, Gabriel Ejai Opolot, appearing on behalf of the appellant, Ms. Rita Izoma. I will like to start by stating that my earlier co-counsel had mentioned I use 7 minutes, but I take up 12 minutes of this honorable court's time, sparing 1 for rebuttal. Much obliged, Your Lordship. Non-monetary contribution in the Republic of Dakar is pivotal to the state, is pivotal to the way society and families are run because of the roles that are taken up by the women in society. In fact, the trial court's decision to undervalue and give a valuation of 20% of the appellant's non-monetary contribution, the appellant contends that this was only a way to increase the already increasing gender gap in society and further the systems of patriarchy deeply entrenched in the Republic of Dakar. Under issue 3, I handle that the appellant contends that the trial court's valuation of her non-monetary contribution at 20% is an infringement of her rights as guaranteed in the Constitution of the Republic of Dakar. I'll handle this under 2 heads of argument. I'll handle this under the head of argument that this contribution undermined the appellant's non-monetary, this valuation undermined the appellant's non-monetary contribution. And secondly, that this 20% violation was in fact a disregard of her rights as enshrined in the Constitution of the Republic of Dakala. If it may please this court, I seek to continue. Much obliged, Your Lordship. Your Lordship, non-monetary contribution is arguably so very important as earlier stated. It is at the very nexus of how families live, of how society is run, because of the work done by the woman. In fact, once courts seek to value non-monetary contribution, the valuation should be in its due valuing this at what was done by the party in question. Arguably so, in AWM versus JGK, a 2021 Kenya High Court Family Division case, in which Justice Mukulu was faced with similar facts as this. He then decided that non-monetary contribution of a woman might supersede that of a man if valuated and valued. This tasks done.
So is that decision binding on this court?
Much obliged, Your Lordship. This decision is only persuasive to this court, given the fact that all these states are common law states and follow these same principles and jurisdictions. It's just persuasive. Thank you. Much obliged, Your Lordship. In the facts of the case, we see in paragraph 11 of the facts, the appellant, Ms. Rita Izoma, worked on the vanilla farm. She managed this farm. Even back at home, she cooked for not her, but the appellant, but the respondent himself, but also their 4 children, but also the farm hands. She cooked, she cleaned, she washed, she farmed, she took goats to graze, she took children to school, day in, day out, for 16 years of their marriage. 16 years, Your Lordships. 16 years, every single day of her life. A national household survey in 2022, as stated in paragraph 5 of the facts. Much obliged. As stated in the facts, paragraph 6, page 3, states that on average, a woman in Dakala a woman of 5 to 10 years and above spends 10 hours or more than the man on unpaid care work. And then after all of this, a woman is valued, her contribution to the matrimonial property is valued at 20%. A UN report on valuing unpaid care work in Mali and Rwanda held inter alia that women's contribution to the property is very pivotal and seen and helps societies run, because the woman is working and spending all her time working, and she's much to the detriment of herself, but the man is only having so much time to keep improving himself. And after the divorce, her valuation is valued at a measly 20%. The appellant contends that this was not seen as justice and this disregarded her rights. Secondly, this valuation disregarded her rights as earlier stated. Rights to freedom from discrimination as enshrined in Article 21 of the Constitution of the Republic of Dakala, which is to the effect that there should not be discrimination on grounds of sex and lists other grounds. This woman is clearly being discriminated against. In a feeder case, it was Uganda Association of Women Lawyers versus the Attorney General, a 2004 constitutional case in the Republic of Uganda, where Lady Justice Bahegaine stated inter alia that women's rights are inalienable and should not be discriminated against. Case law has seen to keep buttressing this point of discrimination. We see Miller versus Miller, a UK case where Lord Nichols held inter alia that there should not be any bias in favor of the money earner, disregarding the homemaker. In this case, we see Mrs. Rita Izoma, the appellant, is the homemaker. She has built work, sweat, and tears every day of her life, Your Lordship. 16 years. 16 years. And then she does it. There are no breaks when you're taking care of the home. You don't have a public holiday. You don't take time to have time for yourself because you want to build your home. and then after, your valuation is held at 20%. Your Lordships, we see this same position. Article 26 of the Constitution gives people the right to own property. Article 31 is against the discrimination on the ground during marriage, at marriage, and upon the dissolution of marriage. This Republic of Dakala, as earlier stated by my co-counsel, is ratified internationally recognized principles, as was seen in page 3, paragraph 7 of the facts.
So you stated that Article 31 is against the discrimination before, during, and at the dissolution of marriage.
Yes, Your Lordship.
Is that a true position of the law?
Article 31
Yes.
of the Republic of Dakala.
Yes.
Yes, Your Lordship.
Doesn't it provide for equality of spouses before, during, and at the dissolution?
Much obliged, Your Lordship. I had meant to say that. I think it was a slip of a tongue. But it is equality at, during, and upon the dissolution of marriage. Your Lordship, in that we see the Republic of Dakala has ratified principles of the CEDAW, which is the Convention against the discrimination against all forms of discrimination against women. In Articles 2, Articles 2, 3, 7 of the same CEDAW, Maputo Protocol, which is to the effect that discrimination against women should not be done on the basis of sex and grounds of sex. We see these same things in the African Charter of Human and People's Rights, the SCHAPR. All these international principles are to the effect that people and women should not be discriminated on the grounds of sex, which is what we see the trial court did in this scenario. 20% valuation, Your Lordships, 16 years for the work done. Thus, in the case of Rabinumi versus Julius Rabinumi versus Hobahim Sobwe, the trial court then had granted the appellant, the appellant had wanted, the respondent had wanted the appellant to be granted a 30% valuation. But the Court of Appeal, in reversing this decision, gave her 50%. The appellant today seeks that this court is persuaded by this, and thus grants that discrimination should not be upheld, upholding the power granted to it under Article 126 of the Constitution of the Republic of Dakala, which is generally to the effect that courts have the power to dispense justice basing on the hopes and aspirations of the people. Among these hopes and aspirations, Your Lordships, is women. 88% of these women, Your Lordships, in the Republic of Dakala, 88% of the women are working in the informal sector, working in unpaid care work. If a decision is made against the appellant today, it will affect her, yes, but it will affect the women in Dakala, it will affect women in Central Africa, in Africa as a whole. It is the appellant here today, but this decision, if made, will affect very many women, and we are fighting to bridge the gender gap. Under issue 4, Your Lordships, the appellant prays that this honorable court grants the relief sought. This power is seen in Article 130 of the Constitution of the Republic of Dakala. It's seen which gives this court as the Court of Appeal the right to subject evidence to fresh scrutiny. In sections 10 and 11 of the Judicature Act, the same position is held. In Rule 30 of the Judicature Court of Appeal Rules Directions, the Court of Appeal has the right to subject evidence to fresh scrutiny. And further, Nasensio Begumisa versus Eric Tibebaga, where Court of Appeal has the powers to grant the relief sought and subject evidence to fresh scrutiny on reassessing the facts. Your Lordships, thus the appellant prays that 1, this property in question is deemed matrimonial property, and thus she is entitled to a valuation of this property 50%, Your Lordships. Secondly, that the trial court's decision to rely on documentary evidence infringed on her rights as enshrined in the Constitution of the Republic of Dakala and the internationally ratified principles that this republic follows. Third, that her non-monetary contribution is revalued at a 50% valuation basing off the principles of fairness and equity and justice for all, Your Lordships. And last, that the costs of this suit are met by the respondent. Summarily, Your Lordships, the gender gap in Dakala is widely increasing. It's increasing at a fast rate, and courts have the power to dispense justice, remembering that they today stand at the periphery and the ethos of justice to create form in the land reform and family matters. To disregard that trial court's decision that the appellant contends was only entrenching the systems of patriarchy as seen in this constitution, and reach its own decision, trying to uplift the values and the principles of fairness for women, which will not affect only this lady, Rita Ezoma, but so many other women in the Republic of Dakala. If I am of no further indulgence, this honorable court, I cede to submit the floor.
Okay. By timing, are we still on track? Are we still on track by our timing? Respondent?
May it please this honorable court, for the record, I am John Isaac as counsel for the respondent. I will be addressing this honorable court on matters that has been raised by the appellant, specifically on issue 1 in 11 minutes, and my co-counsel will respond to issues that have been raised in 12, and 7 minutes respectively. Your Lordships, today we stand here to champion the fundamental principle of gender equality, which is a cornerstone for social development, benefiting both men and women in the Republic of Dakala. And your Lordships, upholding this sacred right enshrined in our Constitution requires that there is rejection of misguided notions that one gender's advancement necessitates the other's diminishment or everyone else's diminishment. Before I go into my addressing on issue 1, I would concur with Land Counsel for the appellant in regards to the fact that this honorable court has jurisdiction and this matter is appellable and admissible in this honorable court. Your Lordship, may it please you that I move into delving into issue 1. To respond to matters that have been raised by the appellant in regards to matrimonial property, by citing the case of Rabinumi versus Bahimbisomwe, Supreme Court Civil Appeal number 16 of 2009, and noting that matrimonial property and contending that the suit land is matrimonial property, we actually submit that the suit land does belong to one of the 3 categories that were noted in that particular case, but it is the category that is not considered matrimonial property, which is land that is acquired before the conception of the marriage. And in accordance with the case, it notes that this property is not matrimonial property, since matrimonial property is that which has been agreed upon by the parties to the marriage to call home.
So, can you address us on the facts where it is stated that that land was obtained before the marriage?
Much obliged, Your Lordship. The facts are clear in paragraph in paragraph 10 of our fact sheet that the parties moved on to the property, and this was customary land. Parties moved on after the marriage had been conceived. And also, looking at paragraph 17 of the fact sheet, it is evident that this property is customary land that has been belonging to the Okoye family for generations.
Council, how do you harmonize that with paragraph 9 that says that they had already had a ceremony which was traditional in 2006, the church marriage was in 2007, and that is when they moved to the land?
Much obliged, Your Lordship. Your Lordship, paragraph 9 notes that they had celebrated customary marriage in 2006 and had their church marriage in 2007, after which they moved to the land. And paragraph 17 specifically notes that this land has been belonging to the Okoye family for generations.
And so can you read for me the paragraph, under paragraph 9, the line that starts that they lived verbatim of the facts?
Much obliged. They lived on the piece of land comprising 5 acres. They moved onto the property shortly after conducting their church marriage in 2007.
Thank you. What does after mean?
Shortly after conducting their church marriage. The shortly is important to this. If I am, please. Yes, please.
Did the couple acquire this property after or before, regardless of whether it was shortly after or a long time after?
The couple, in accordance with paragraph 9, moved to the land after the conception of their marriage. They had not been living on the land before their marriage.
My last question on that issue. Hypothetically, if a couple was married and they were renting, and after their marriage they purchased property, does that property constitute matrimonial property, or because they have just had it shortly after their marriage, it's not matrimonial property?
In accordance with the case of Rabinumi versus Bahimbi Somwe, the couple can actually acquire property and call it home even after they have conceived the marriage. But this property has been belonging to the Okoye family for generations, even before their marriage. So it was not procured after the marriage, but rather it was more settling on the property than procurement by way of purchasing and acquisition.
Council, still on that matter. So is your argument that the only way you acquire property is through a sale and buy arrangement, that you cannot acquire property from a family arrangement?
Much obliged. There are other ways of acquisition of property, some of which could include when the property is bequeathed to a person, but that requires express provisions. And without the same, it would be problematic to argue that this couple actually had ownership over this land, since there is no express proof towards the same. Much obliged. It is equally our submission that, in response to matters that have been raised by my learned colleague, that the respondent is praying for, I beg your pardon, the appellant prays for usufructory rights as an alternative to ownership of the property. It is our submission that this prayer is strange to this suit, to this application, as it wasn't amongst the prayers prayed for in divorce cause number 34 of 2022, which is being appealed against. The only prayers that were made were in regards to ownership of property, and specifically 50% ownership, or value that is commensurate to the 50% ownership of the property. It is therefore our submission that this prayer is strange to this honorable court, and a prayer that it is not entertained. Furthermore, it is our submission that in the bid to safeguard the rights of the appellant, this honorable court cannot be seen procuring a miscarriage of justice against the persons belonging to the family of Robert Okoye. And acknowledging that rights to property and equality in marriage and at its dissolution, we submit that this land, in accordance with paragraph 17, it belongs to the Okoye family, that has been held for generations in their family. This land is dwelt on by their ancestors, has been lived on by their parents, and sharing a 50% or awarding a 50% share to the appellant is in a way prejudicing the rights of all the other members of the Okoye family who equally have ownership rights over the property as it is customarily owned by them. It is a prayer that awarding 50% share will be negatory towards every other person who has a right to this property. Your Lordship, I will submit on looking at the case of Rabinumi versus Bahimbi Somo, as earlier mentioned. It was also contended that a party can hold property separately from their spouse. And this is reaffirmed in the case of Uhiriwe versus Kuku and two others, where it was...
Counsel, are the facts in Rabinumi case distinguishable from the facts at hand for us to be bound by that position?
The facts are distinguishable, but this is persuasive in nature. And this honorable court is at pleasure to either abide by or make its own decision, as it is required in further Nasensio that this honorable court has authority to make its own decision after re-evaluating the evidence that has been placed by the parties as a first appellate court. My time is running short, and I would like to make my conclusion that this property, the suit land, does belong to the Okoye family. It is held by Robert Okoye communally with the Okoye family and separately from the appellant. And it would be prejudicial to every other person who has rights over this property to award a 50% share towards the same. If I have no further indulgence, I beg to submit and welcome my colleagues.
May it please this honorable court, for the purposes of record, I am Counsel Amanya Belinda. I beg to proceed in resolution of issue 2 and 3. In resolution of issue 2, which states that whether the trial court's decision not to grant the appellant 50% of the value of the property on which her and the respondent's matrimonial home was situated on account of the fact that she did not produce documentary evidence in the form of receipts is in contravention of the legal provisions relating to the right to freedom from discrimination, the right to equality at marriage, during marriage, and at its dissolution, as well as the right to property in the Judicature Act and the Constitution of the Republic of Dakala. My Lordships, Council Evelyn starts by asserting that there was no monetary contribution. But then we ask a question, what amounts to monetary contribution? Isn't employment a monetary contribution? To an extent where the opposite council asserts that we have had women employed in the informal sector and then claim that it is not a monetary contribution, then we wonder. More to that, if that wasn't the case, then why are the extra farmhands that are needed paid? It is a form of employment. And on that basis, I would like to proceed and say, according to paragraph 11 of the fact sheets, it is well proven that this lady was offering labor in the farm, which amounts to a monetary contribution. And to that extent, where they negate such and decide to discuss on matters that are not of monetary contribution, then they move out of scope of the discussion in issue 2. Moving forth, Moving forth, the appellant connotes to the fact of record keeping and assert that Rita Izome has not attained education, formal education. The description of formal education actually includes even primary education because it is a form of formal education. Informal education is one where you sat under a tree and you probably lectured by your fathers and mothers. But to the extent where formal education is that you go to an entity called a school and you're lectured and taught, that amounts to formal education, and would like to make clarity on those facts. Proceeding to the arguments under this issue, I would like to proceed with 2 head arguments. Argument 1 being that the appellant is only entitled to a share commensurate to the degree of contribution, which is and must be proven by documentary evidence. Otherwise, it remains a baseless claim.
So do you have an authority that the proportion of property to be shared is and can only be proved by documentary evidence?
I do have a persuasive case to that. In the case of Abdallah Saidai versus Mwanakum Yusuf of 1977, it was held that the degree of contribution that is monetary must be proven by documentary evidence. Because then how then will we commensurate it or amount it? More to that, we move to the point of record keeping. They claim that she's not well educated to keep records. For a person who has been in business or in farming for about 10 years, 15 years, there must be a progressive record keeping for sustainability. And that does not require formal education, but that is a common practice that is done by people that have been in business for long. Or either way, could we say she would not note anywhere, or she cannot remember how many times she has worked, so that we try to have an option for the receipts. And therefore, without proof...
Is it your position that her being a spouse was a business and as such she ought to have kept the receipt for the 16 years she was in the union?
No, that is not what we assert in this matter. However, what we are trying to prove is if there has been payment of her equivalents who have been working in the farmhands, their receipts could amount to the days and the time they've been there. But where they have not been provided, it remains a baseless claim which should not be entertained in this honorable court. I proceed on my second head argument, which states that...
A moment. So do you agree by your arguments that the appellant then made a contribution that was both indirect by virtue of her unpaid care work and domestic work, as well as a monetary contribution through her employment?
Yes, I do.
So she made both a monetary and indirect contribution?
Yes, and to this issue 2, I am handling the monetary, and in issue 3, I'll be discussing the non-monetary contribution.
Okay.
Moving forth, my next head argument is that the requirement of receipts is necessary for promoting 1, fairness, transparency, and accountability, which are values that are held by this honorable court. More to that, under Article 21 of the Constitution of Dakala, it talks about equality under the law. At this extent, we get to look at the case of opposing counsel as one which is discriminatory in nature because it only looks at Rita Izome and forgets that the property in question is customary. It has an entire family and lineage of the Tonga clan, and Okoye family who are parties and owners to that land. And therefore, in such a matter, where critical issues like receipts to protect any violation of the rights of such people, and Robert in this matter is a violation to these people's rights, and we do request this honorable court not to move forth with such a violation. Allow me proceed to issue.
Just a question on that submission. If by their staying on the land during the sustenance of the marriage for the 16 years, Robert and the spouse were enjoying that land and it was not detrimental to the interests of the community, how is it now at the dissolution that it's going to affect their rights?
The extent to which it becomes detrimental is when you talk about ownership, there is a part that is being taken. And in the matter at hand, we are looking at a 50%. Then does the entire family remain with 50%, which is an injustice to the entire family, and that is what we are looking at. But usership does not affect them because they remain the owners, so that you can use the land, but when it gets to ownership, which means excluding and taking a portion, then that becomes an injustice to the Okoye family. Proceeding to issue 3, which clearly speaks to whether the trial court's valuation of the appellant's non-monetary contribution in the form of unpaid care work at 20% rather than 50% of the property on which her and the respondent's matrimonial home are situated contravenes legal provisions. My lordships, I would like to start by stating the case of Ambayo Joseph versus Aserua Jacqueline of 2005. It was held that it was held to interpret Article 31, which speaks of equality at marriage, during marriage, and at the dissolution of marriage. That this equality does not speak to 50 by 50. It is not take a half, I take a half. However, it is one that the matrimonial property must be based on fairness and consciousness. Backed by the case of Francis Njoroge versus Virginia Wanjiku, it is clearly held that division of property must be decided after weighing peculiar circumstances of each case. If we are to make a critical analysis of the property in question, this is not property that is single-handedly owned by Robert Okoye. However, this is customary land. It is owned by the Okoye family. And therefore, such peculiar circumstances, when not weighed, we will be creating a discrimination and an injustice on the Okoye family. And I would like to hold my lordships and say, I would like to proceed to do an introspective and retrospection of the facts during the marriage. What happens during the marriage? On page 11, which they clearly negate, it starts by telling us that, on paragraph 11, it starts by telling us that together with Robert, Rita Izoma manages the process of harvesting and selling vanilla, which also points to the fact that the proceeds that come from this vanilla plantation is not only a contribution of Rita Izome, but a contribution of a husband and a wife. And to that extent where you want to paint...
On that very paragraph you've read, can you read for us the third sentence?
Okay.
On paragraph 11.
Paragraph 11 says, line 3?
The third sentence that starts with 80%.
80% of the proceeds from the sale of vanilla would be kept by Robert. I will argue this in this way, my lordships. When we look at the financial burden that Robert Okoye has, which one speaks to payment of school fees for the children, maintenance, taking care of them and the entire family, especially when it gets to health needs, when we also proceed to the purchase of seeds, materials, tools, and machineries, and paying of farm hands, this is an economic or financial responsibility that Robert Okoye had. And therefore, the 80% accounts for that. More to that, if we had any proof to the fact that Robert Okoye had developed himself as an individual or has a sign of misuse of this money, then we would proceed and hold that Robert Okoye is cheating the wife, Rita Izome. But to the extent that we look at a visible cut of the responsibilities that are financial that Robert Okoye has, it is...
So there is evidence in the fact that Robert Okoye was cheating Rita. The first paragraph of paragraph 12.
Much obliged, Your Lordship. Cheating does not amount to a financial responsibility or misuse of money. Cheating involves two people involving in sexual activity, which may not be based on finances, Your Lordships. Proceeding to that, I would like to say that this Honorable Court should uphold a differential treatment and differ from the fact that it is looked at as discrimination. And this is why I prefer to call it a differential treatment. When we proceed to look at what happens at the dissolution of the marriage at paragraph 15, it is held under C that maintenance in respect of the 4 children to be paid by Robert. And to the extent where it's supposed to be paid by Robert, it still caters for Rita Izome herself because she also has custody to the children, and therefore it is not it is an injustice for this Honorable Court to hold that that Rita Izome needs an increment from 20% to 50% if Robert Okoye's financial responsibility still holds, still stands, and is much needed for the
Counsel,
subsistence.
is it a true
of the
position
family.
of the law that the maintenance here, as envisaged, extends to the woman?
Yes, it is, and this is why I state so.
Could you cite for us the law?
Correct.
I'll decide to go with the persuasive side and state that by virtue of the fact that Rita Izome also has custody of the children, therefore, in the responsibility that Robert Okoye has, it will still extend to her as one who is holding custody of these children and remains a responsibility of Robert Okoye.
And so then what is the distinction between that support in custody and the common notion of alimony that we know? Are they still the same?
I beg your
Because
pardon, Your
you seem to be leading us that contribution to custody and maintenance of children, by extension, still means contribution to support of Rita. Is that the same? Is that your argument?
Yes, it is.
And so would that be then equated to the principle of alimony?
No.
Want to wind up?
I would like to relinquish the floor to my next counsel.
May it please this Honorable Court, for purposes of record, I'm Counsel Nakale Hajara for the respondent. Your Lordships, I'll be handling issue 4 and the prayers to this Honorable Court. I pray to proceed. Your Lordships, the appellant submitted to this Honorable Court to seek relief that this Honorable Court grants a 50% share of the matrimonial property, which is situated on the ancestral land of the Okoye family, which is customarily governed. Your Lordships, the appellant further submitted that they seek relief to an increment of 20% to 50% for the appellant's unpaid care work, Your Lordships. Your Lordships, the appellants further submitted to this Honorable Court that the court should really not consider the documentary evidence in valuation of monetary contribution towards Your Lordships, the appellants further submitted to this Honorable Court that the trial court should really be lenient to documentary evidence when it is really handling matrimonial property at the dissolution of the marriages. Your Lordships, it is our submission that this Honorable Court does not grant the appellant the relief sought. Re-echoing on the submissions of my co-counsel to support our submission. Your Lordships, the land where the matrimonial property, the property in issue, is situated on a customary land, which is an ancestral land owned by the Okoye family. The trial court perfectly provided for the law in the Constitution of Dakala, that's Article 26 of the Constitution, which grants the right to property to the citizens, your lordships. The right to property should be, this implies that the right to property should be really emphasized by ownership, of which in paragraph 18b of the fact sheet, the trial court ruled that both of them didn't have ownership to the matrimonial land, to the land in suit. Your lordships, we submit to this honorable court that indeed, in the case of Rima versus Rima, that the court acknowledged different standards for marital claims, but emphasized the need for substantiation. Your lordships, allowing claims without sufficient evidence can lead to misinjustice. Your lordships, in paragraph 18b, it really provides that the appellant really failed to prove documentary evidence in her assertions for the monetary payment, for the monetary share of the matrimonial property. Furthermore, to respond to the issue of an increment to 20%, from 20% to 50%, as prayed by the appellant, your lordships, the appellant should be appreciative of the trial court's decision. It recognized her unpaid work by granting her 20% of her unpaid work. Your lordships, the trial court really considered that our respondent, Robert Okoye, has financial burdens. In paragraph 19, in paragraph 11, it is evidence that Robert Okoye would pay the school fees for the children, purchase the seeds, materials, tools, and machinery needed for the vanilla farming, in addition to paying the farm hands. Your lordships, the court must maintain strict standards to protect against unfounded claims based on mere assertions, as the appellants really contend to for their prayer when granting monetary contributions, since evidence is really key while proving monetary contribution.
Counsel, on that very issue under paragraph 17, they were admitted at trial by Robert. So how do you harmonize the position of your submission and his admission at trial? So,
your lordships, your lordship, much obliged. Indeed, the respondent contended that the appellant really done that work, but not monetary. He contends that he did the unpaid work, which is non-monetary.
Does that exclude that kind of work from being considered at the dissolution of marriage?
Your lordships, it's not. It is really considered. However, with proof. That's in case of monetary contributions. Your lordships?
Have you addressed your mind to the case of Ambayo versus Aserua?
Yes, your lordship.
What was the principle in the valuation of unpaid care work?
Your lordship, I pray you paraphrase for me the question.
If you've addressed your mind to Ambayo versus Aserua, what principle was put forward by the judges of Court of Appeal in regards to valuation of unpaid work in determining the quantum of distribution as regard percentages?
Your lordships, in that much obliged, in that case, the court really considered both monetary and non-monetary contribution towards the development of the matrimonial property. However, it considered that the court should consider the market value of the unpaid work. It should consider the it should consider the age of the person in issue, and also, yeah, that's the principle. Your Lordships, as the respondents, we pray, it is our prayer, that this Honorable Court upholds the trial court's decision, affirmative that Rita Izomas is not entitled to the relief sought, and it is our prayer to this Honorable Court that the appeal be dismissed with costs. We so submit.
Thank you. Response, if any, from the appellant.
Much obliged, my lord. The issue in contention before this honorable court is not matrimonial property. The issue is, 1, the rights of women on land. Secondly, their contribution. And thirdly, the relevance of evidence. The respondent's case fails on all the 3 grounds. Why? We use matrimonial property inter alia in Chintu versus Chintu in my first speech to mean also land that can be held in trust for a clan by the husband. Secondly, they disregarded the evidence of the relevance of evidence, which court, when we submitted Article 126(2)(e), they did not address. Thirdly, we discussed the contribution and the gender gaps. These were both left out. And when we discussed the tripart test, when we discussed the United Nations test on discrimination and the state obligation to fight all the rights, this was disregarded. Lastly, just for clarity, they discussed that the provision, they discussed education and employment. Employment is defined in Section 2 of the Employment Act to mean that it provides when there is a contract of service. And in the facts before us, there's not contract of service. We discussed the vulnerability of the woman in question. This they clearly disregarded, did not prove to us that she was actually not vulnerable and therefore does actually just simply deserves 20 rights. We discussed the use and we discussed the use and the relevancy behind property rights. I beg your pardon. We discussed the use and the relevancy behind property rights, which they did not actually tackle, and therefore the 3 grounds raised by the respondent fail. We therefore conclude and pray to this honorable court. We therefore conclude and pray to this honorable court that they will take cognizance of the fact that our issue of usufructory rights, we only wanted to assert that because of those usufructory rights, she has the same rights. Both of them have usufructory rights as opposed to ownership of the land, as the question was raised by the judges before the respondent's case. And lastly, we would like to say that they did not meet the standard laid down in equality and discrimination. My lords, if I'm of no further indulgence to this court, I beg to submit.
Any additional submissions to support from the member of the bar for the appellant?
Much obliged, my lord. Our rules are to the effect that we only get 1 speaker to give us rebuttal.
Okay. So thank you very much. We have concluded the first oral sessions. We will sit back as judges and evaluate, and then communications will be made in due course as regard your performance and our comments thereafter on the proceedings before this court. Thank you.
internationally known on the mic. You know they using me. Maybe it's the money, or maybe you ain't used to me. Cause you was depressed and now you abusing me. That's why I need me a girl to be true to me.
obliged, Your Lordships. For purposes of court record, if it pleases this Honorable Court, my name is Nabakoza Faith Kakoza, appearing for the appellant, Ms. Rita Izoma, together jointly with Counsel Mwine Andrew. And
Please
Counsel
give us
Mutesi.
2 minutes, and then we can commence.
Much obliged, Your Lordships.
We can continue.
Much obliged, Your Lordship. Once again, for the record, my name is Nabakoza Faith Kakoza, appearing for the appellant, Ms. Rita Izoma, and together we are appearing with Counsel Mwine Andrew and Counsel Mutesi Sandra. Your Lordship, if it pleases this Honorable Court, I beg that Counsel for the Respondent introduces the bar.
If it may please this Honorable Court, my name is Akankwasa Isabel, together with my teammates, Miss Evelyn Nsemere and Mr. Gabriel Ejai. We are counsel for the respondent, Mr. Robert Okoye.
Much obliged, Your Lordship. We'll be using 10 minutes of court's time out of the 30 minutes that have been awarded to us. Counsel Andrew will use 12 minutes and Counsel Sandra will use 5 minutes. I'll be handling the first issue. Co-Counsel Andrew will be handling the next 2 consecutive issues, and Counsel Sandra will handle the last issue, Your Lordship. If it pleases the Honorable Court, I'd like to delve into the merits of the appeal. Your Lordship, we appear before this Honorable Court under Article 134 of the Constitution of Dakala in tandem with Section 11 of the Judicature Act of Section 10, I beg to be pardoned, Your Lordship, of the Judicature Act of Dakala, which grants this Honorable Court powers to hear an appeal arising from the decision of the High Court. I'll therefore devolve into the summary of arguments of the appellant. Your Lordship, the appellant is going to argue before you, this Honorable Court, that the trial judge's decision not to grant a share of the matrimonial property and failure to give her 50% as a requirement of producing documentary evidence, and failing to award 50% of non-monetary contribution was indeed in violation of her rights to property, her rights to freedom from discrimination, and her right to equality in and at the dissolution of marriage. Your Lordship, I beg to proceed. Your Lordships, the facts of this case are that the appellant and the respondent had a marriage that was abstaining until 2022, where the appellant decided to petition to court for a divorce on grounds of cruelty and adultery, and sought for orders of custody and maintenance of children and an equal share of property. Prior to that, the appellant and the respondent stayed in a village known as Kaduna and district of Konde, where they stayed on a land which was 5 acres, and the appellant, together with the respondent, were able to come up with a 5-bedroom house. And on that same land, they had a vanilla plantation where they got the proceeds out of which they were able to construct that same property. Your Lordship, out of that, they also had crops on which they would derive their sustenance. And on that note thereof, the appellant provided an monetary contribution through her support, tilling the land, harvesting it, and giving food to the workers, in addition to non-monetary contributions such as washing clothes for the respondent, taking the children to school, and giving home care as any woman would do, Your Lordship. When the divorce was petitioned before the High Court of Kondi, the trial judge indeed heard the matter and gave a decision that the marriage should be dissolved. However, there was no decision in regards to equal share of matrimonial property, and the trial judge also valued 20% of an alimentary work, which was dissatisfactory to the appellant, and hence this appeal. I beg to proceed, Your Lordships. Your Lordships, the grounds of the appeal were two, that is that the trial judge erred in law by failing to apportion a property to the appellant in failure or disguising by the fact that the appellant did not own this land, neither the respondent owned this land. And also the trial judge erred in law by failing to apportion 50% of non-monetary work, and out of that, we were able to draw up 4 issues together with counsel for the respondent in the scheduling conference, and I'll be having issue 1, Your Lordship. I beg to proceed. Issue 1 states that whether the trial court's decision that the appellant is not entitled to any share of the property on which her and the respondent's matrimonial home was situated is in contravention of the legal provisions relating to the right to freedom from discrimination and the right to property in the Land Act and the Constitution of the Republic of Dakala. Your Lordship, the aforementioned rights are not new to the Republic of Dakala. They have been provided for under international statutes. To mention a few is the Article 17 of the Universal Declaration of Human Rights, which clearly stipulates that every person has a right to own property alone and in association with others. The same provision has been reiterated under Article 15 of the ICCPR. Your Lordship, according to page 8 of our submissions, I beg that the bench follows with me, that we were able to abbreviate those conventions, Your Lordship. The same is provided for, and an inference is made under Article 11.1 of the ICCR, and to that, an effect is also made under Article 16 of the CEDAW that seeks that partner states shall at all times fight all means of discrimination against women, especially relating to marriage. And Your Lordship, the same provision is provided for under Article 14 of the African Charter of Human and People's Rights. The same is reiterated under the Maputo Protocol, Your Lordship. The same provisions have been domesticated under the laws of Dakala, that is Article 26 and Article 21 of that Constitution, that provides for right to property and freedom, respectively. Your Lordship, the state of Dakala, in regards to the facts, it is clear that it is a dualist state and it has adopted and ratified, that is paragraph 7, page 3 of the hypothetical case facts, that the state of Dakala has ratified these conventions, and it is incumbent on it to at least progressively realize these rights and perform its obligations under the treaties. It is also a principle of international law that pacts at Savanda that parties must at all times keep their agreements to the effect, Your Lordship. The matter at hand is to determine whether the trial judge indeed erred in law by failing to apportion a property. Your Lordship, in regards to sharing matrimonial property, it is important that the first thing that the party has to prove is that this property in question is matrimonial. Your Lordship, what then amounts to matrimonial property? In the case of Rabinumi, Julius Rabinumi versus Hope by Himbisobwe, Civil Appeal number 100, where the trial judge borrowed the definition made by Bosaje, as he then was in the case of Muwanga Chivumbi versus Kintu. He clearly stated that matrimonial property is understood differently by different people. There is always property which the couple can choose to call home. There is also that property that the husband holds in trust for the other people. Then there is also that property that a person can gain before marriage. In the instant facts, Your Lordship, the appellant stayed on this land with the respondent after their marriage, Your Lordship. On this same plot, this plot was actually was owned by the family, but what is in contention is the matrimonial home, which eventually is situated on the land. How that becomes matrimonial property, it is a principle of land that quicquid plantanta solo solo sedit, that whatever is attached to the land then becomes part of the land. That is how this land becomes matrimonial property. The second issue will be determining contribution, Your Lordship. Your Lordship's contribution could either be monetary or non-monetary, and in the case of Ambayo Aserua, Ambayo Jackson, Your Lordship, I beg to be pardoned, Ambayo Waigo Joseph versus Aserua Jacqueline, Your Lordship, it was clearly stated that non-monetary contribution is also put into consideration. After ascertaining those two, then we have to find out, Your Lordship, was the trial judge indeed right, or she actually erred or occasioned a miscarriage of justice? Your Lordship, in the decision of the trial court, it clearly stated that the reason as to why it could not award this property to the appellant was simply because it did not belong to any of them. However, this was an error in law because the trial court failed to address Article 26 of the Constitution of Dakala, which clearly states that land could either be owned in association or communally with others. When the article thereof states communally, it technically is pointing you to customary tenure of ownership. What then governs the ownership of customary tenure? Clearly, that is...
So Faith, are you saying it's only under customary tenure that you can own land communally?
No, Your Lordship. But you can own land on any types of tenures because ownership of land communally is essentially either joint tenancy or tenancy, joint tenancy or tenancy in common, something like that. So it can accrue to any. But when you talk of communal, because customary tenure is peculiar to communal, it is so rare to find communal association in other tenures. Not saying that it doesn't happen, but it is very key to customary tenure ownership of land.
So Article 26 does not apply only to customary land?
Much obliged. Your Lordship, it therefore follows that the trial judge finding that the property did not accrue to the appellant because it did not belong to any, it was erroneous in law because land can be owned even in association with others, because when the people on this land, what they own are user rights, which rights could also be accorded to Miss Izoma. It therefore follows, Your Lordship, the trial judge also occasioned a miscarriage in justice by not addressing Section 27 of the Land Act of Dakala as amended, Cap 236, Your Lordships, because that section is to the extent, and it is clear, that customary tenure can be governed by customary laws. However, if those laws end up being inconsistent, first, to the rights of women, to the rights of children, and to the rights of people with disabilities, then they have to be considered null and void. So the trial judge did not put into consideration Article 22, which provides that the Constitution of Dakala ought to be having priority over any other laws in Dakala, especially those that are inconsistent to any written law, Your Lordship. And therefore, the trial judge also was erroneous by attaching a high probative value on customary laws as opposed to the Constitution, Your Lordship. Therefore, it follows, Your Lordship, in a well-celebrated article by a law done in the state of Uganda, known as Proving Customary Tenure by Dr. Rose Nakai, she clearly states that customs at all times, even in regards to customary tenure, must be in the same spirit with the Constitution. And to the extent that they are not, then they can be considered as inconsistent and bad law to that extent, Your Lordship. It therefore follows that even when customary tenure is governed by customary laws, it does not bar or it does not oust the jurisdiction of the court to inquire in those laws, especially if they have been brought to them, Your Lordships. Therefore, the trial court...
So in light of that position that you're stating, how would you balance the interests of those that hold land customary as provided for in the facts, and then the position that you're submitting on?
I beg to restate that question again.
Balance the interests of those that are already in the land and the position you're just submitting on that, yes, indeed, every other custom should be subject to the Constitution, but the very Constitution also gives the community land to own, gives people land to own land communally.
Much obliged, Your Lordship. The hierarchy of laws is that the Constitution takes priority over any other laws. And Article 2.2 is to the effect that even when customary laws, I do not dispute the fact that customary laws are applicable to customary tenure, but to the extent, that is why I quoted Section 27 of the Land Act, that to the extent that those laws are inconsistent, then they cannot be relied on. And for us to balance the rights, remember, Your Lordship, is that these people have user rights. Yeah, giving a portion of those same rights to the appellant does not take away the rights of the people of Okoye family. Your Lordship, in that same article, Dr. Rose
Wait,
Nakai...
just to take you back a bit. In your definition of matrimonial home, you alluded to about 3 elements. So they could call it home. It could be land that is held in trust for other people, like a clan, according to that decision. So which exactly are you relying on? Because a decision has a differing number of explanations for what amounts to.
Your Lordship, in this state, I actually would like to rely on the decision that Justice Remy Kasule gave as his lead judgment, where he said that it could also be that land that the husband holds in trust. That clearly means that as the husband holding in trust, he has a portion of that land.
Does that mean you own the land? When you are a trustee, are you an owner?
But you have rights over that land.
Which kind of rights?
Equitable rights, Your Lordship.
You may proceed.
Your Lordship, it is also clear that the fact that the trial court barred and fettered its discretion by failing to inquire into the customs of Tanga was discriminatory to the appellant and was also not fair because it derogated her of her right to property. Your Lordship, it is also important to note that even when the Constitution provides, because if you look at the Land Act, it provides that ownership or governance of this land can be by communal associations, or it can be based on the clan members or the sub-clans.
So your time is up.
I beg for 1 minute to conclude, Your Lordship.
You have 1 minute.
It therefore follows, Your Lordship, that the powers granted to the clan leaders to hold this land do not go as far as determining who has property rights thereof, Your Lordship. It is also important to note that the trial court did not put into the dire consequences of depriving a lady a right to property, because when you deprive her of a right to property, you deprive her of livelihood, of sustenance, and for living. Because this is a lady who has been on this land for 16 years, Your Lordship, 16 years. What is going to happen to her? She has been tilling this land. Now she has no share of this property. It is therefore that this honorable court shall put into consideration that the rights of women and under the duty that courts have to support women in all spheres, and overturns the decision of the trial court and find that the appellant is indeed entitled to a share of the matrimonial property. I beg to submit and relinquish floor to co-counsel.
Much obliged, Your Lordships. For purposes of court record, my name is Mwine Andrew, and I'm co-counsel representing the appellant, Miss Rita Izoma. And I'm going to handle issue number 2, my lords. Unless advised otherwise, I beg to proceed. Issue number 2 states that whether the trial court's decision not to award 50% on grounds that there was no production of non-documentary evidence in form of receipts contravenes the right of the appellant to freedom from discrimination, her right to property at marriage, during the marriage, and at its dissolution that is indeed guaranteed in the Judicature Act and the Constitution of Dakala. My lords, we beg to state that when courts are indeed faced with a decision as far as matrimonial property and its divisions are concerned after a dissolution of marriage, indeed they are construed to look at documentary evidence. But where such evidence is not, my lord, they are indeed inclined to look at the real-life testimonies that are given by the parties in court. And these are real-life experiences and collateral circumstances. I beg to arm myself, and I beg court to find this persuasive by the court of Ambayo Jackson, by the decision made in Ambayo Jackson versus Aserua Jacqueline, where a court stated that if testimony tallies with the real-life experiences of the parties, then indeed that testimony is truthful. But where the testimony deviates from the real-life experiences of the parties, then indeed that testimony might be found untrue unless reasonably explained. It's our averment, my lord, that in the High Court, the appellant indeed gave real-life testimonies where she said that she was on this land for 15 years and an additional 1 year, my lord. Those are indeed 3,975 days, waking up every day, tilling the land, waking up every day, washing clothes, even for the respondents, my lord. And in this testimony, it was not fictional, it wasn't a movie, but indeed it was real life experience, my lord. So we indeed aver that the High Court's decision not to award 50% was indeed discriminatory and based on sex other than the facts and the law, my lord. My lord, in the case of Chivuitu versus Chivuyutu, a case that was decided between 1990 and 1994, they accorded contribution in two ways. There is monetary contribution and there is non-monetary contribution. Non-monetary contribution, my lord, was defined in the case of Ambayo Jackson, Supra, my lord. And they said, this is unpaid care work and domestic work, my lord. This means that every work that a man and a woman does on a daily basis, which is not compensated by way of wages, amounts to non-monetary contribution, which becomes unpaid care work. My lord, this kind of work has been recognized internationally. The International Labour Organization values unpaid care work at 1% of the global gross domestic product. 1% equates to 1 trillion United States dollars, my lord. Of the 1 trillion United States dollars, 6.6 trillion is contributed by the women, and 2.4 trillion is contributed by the men. My lord, the appellant is indeed part of the 6.6 trillion contribution among the women. My lord, we are not only here for the appellant, but even the other women that don't have voices in order for courts like this to hear them. It is indeed our averment, my lord, that if this work is recognized internationally at a tune of 6.6 trillion for the women, and the High Court decides and says that no, it is not like that. We should award you only and only, we should not consider your contribution in terms of non-monetary contribution. We therefore, my lord, the High Court decided that it is the decision was made in the form of not awarding 50% of the non-monetary.
Valued her contribution.
Yes, it did. Indeed, it valued. Our averment is that it was valued at a low scale and not at the actual scale, considering her contribution, my lord. Much obliged. Going further, my lord, if this work amounts to 6.6 trillion and the High Court awards that small percentage, but also in that does not even award 50%, indeed, that this decision was based on discriminatory parameters and not on law and the facts, my lord.
Counsel, on your position that the appellant was entitled to 50%, what guides your conclusion on that? How do you arrive at the 50%? Could you point us to any particular paragraphs or information that makes you arrive at the conclusion that 50% is equitable and reasonable?
My lord, when you look at the facts, considering the non-monetary contribution that in paragraph 6, my lord, the facts state that the 2002 International Labour Organization's report showed that indeed the non-monetary contribution of women is far much higher than that of men, my lord.
Counsel, please point us to the facts concerning the parties. How did you arrive at the fact that you're praying for 50% instead of 20%?
My lord, I would invite this court to look at paragraph 11 of the facts. In that paragraph, my lord, other than the facts telling us that indeed the appellant was doing much more as far as the contribution is concerned non-monetarily, but even in paragraph 7, page 3, it also states the fact that the women in Dakar spend 10 hours a day doing work on the fields, doing work as far as the culture is concerned. And because the respondent puts in monetary contribution does not negate the fact that the non-contribution cannot amount to 50%.
Council could also point you to paragraph 11. I think you could also address court on how the proceeds were shared.
Much obliged, my lord. We affirm, my lord, that indeed the proceeds were shared. But when you look at the fact that the appellant was using the same proceeds from the vanilla to contribute to what amounted to a home at that time, it means that she was doing much more, doing non-monetary and also monetary contribution at that time, my lord.
How was the respondent contributing?
My lord, the respondent was contributing in a monetary way, in terms of money and also in terms of wages.
Where was he getting the money?
He was getting the money from the vanilla plantation.
And
which, my lord, the appellant was the one who was working on the vanilla plantation more hours than the respondent.
Okay.
Much obliged, my lord.
So the money from the vanilla is what was used to pay for the house.
Much obliged, my lord.
So is that a monetary contribution as well?
The money is monetary contribution, but the produce from the vanilla is non-monetary, which was contributed by the appellant.
So did the appellant make or not make a monetary contribution as well?
The appellant indeed made a monetary contribution as well.
Okay.
Much obliged, my lord. My lord, I would like to invite this court to the fact that when courts are making decisions concerning husband and wife, there shouldn't be strictness as far as considering non-monetary contribution is concerned. In the case of Rimas versus Rimas, my lord, a case of 1952, volume 2 All England report on page 863, I beg leave of court to read it verbatim. Court said, in cases between husband and wife, courts ought not to be governed by the same strict considerations, both at law and equity. My lord, when the High Court decision was being made, it indeed relied on strict conditions that govern them, and did not look at the fact that when evaluating non-monetary contribution, non-strictness should be applied in order to make a wholesome contribution percentage, my lord. I would also like us to be aware of the fact that equity looks at substance rather than form, my lord. It defeats equity not to award the appellant 50% of the value, and your basis is non-provision of documentary evidence, which in this case, my lord, is so strict. You cannot give a receipt for your cooking at home. You cannot give a receipt for your washing clothes, even for the respondent. You cannot give a receipt even for slashing the compound, which actually the respondent should have been doing, but the appellant indeed did. So it means that if court does not look at this, it will indeed have taken form other than substance. We therefore pray, my lord, that court finds that the trial court's decision not to award 50% of the value of the property on grounds of non-production of receipts in form of documentary evidence was indeed based on parameters that are discriminatory and contravened the appellant's right to property at marriage, in the marriage, during, and even at its dissolution. Moving on, my lord, unless advised otherwise, I would like to handle issue number 3, which states that whether the trial court's valuation of the appellant's non-monetary contribution in the form of unpaid care work at 20% and not 50% indeed contravened with her rights to freedom with her right to freedom from discrimination and her right to equality at marriage, during the marriage, and at its dissolution. My lord, I'm going to base on the provisions of the Constitution. When you look at Article 21, read in tandem, Article 21, Clause 1, read in tandem with Article 21, Clause 3, you'll find that the trial court's decision indeed did not look at the fact that all men are equal before the law, and used the discriminatory parameters of sex, color, and others in order to make this decision. We therefore aver, my lord, that the maxim says, equality is equity, my lord. Courts are bound to apply such a maxim when considering Article 1 of the Universal Declaration of Human Rights that states all human beings are free and are born equal, my lord. It should be noted, my lord, that where the appellant cannot get equality in her social life, it is only the just courts that can indeed give such justice in form of equality. We therefore aver, my lord, that considering the statistics of the International Labour Organization, we conclude by saying that indeed the trial court's decision was based on discrimination and indeed contravened the right of the appellant to own property at, during, and at the dissolution of marriage. I beg to yield ground for my co-counsel, my lord. Much obliged.
Much obliged, your lordship. For purpose of court record, I am Counsel Mutesi Sandra, appearing for and on behalf of the appellant, Ms. Rita Izoma, in this matter. Your lordship, I'll substantiate on issue number 4, which states that whether the appellant is entitled to the relief sought. Your lordships, on this issue, we, the appellants, vehemently contend that indeed the appellant is entitled to the relief sought. Moving to Section 11 of the Judicature Act, Cap 16, which states that the Court of Appeal shall have powers to hear, determine, and have jurisdictions to determine an appeal. We therefore believe we are in the right court, and this honorable court has all the powers, authority, and jurisdiction to rehear this matter, reevaluate from both parties, and come to an understanding of granting reliefs as it deems fit. Your lordship, we continue to persuasively rely on the case of Kivutu versus Kivutu 1999, East Africa, at page 270, where Justice Omolo of the Court of Appeal stated that having found that the wife's indirect contribution, such as the preparing of children to school, such as the indirect payment of household expenses, preparing food at home, slashing, washing things, amounted to indirect contribution to the wellness and the income that the family got, which entitled her to an equal share in the couple's joint property. Your lordships, the above case is a replica of what Rita Izoma has been doing for the past 16 years. Let it be on record that page 3, paragraph 6, line 7 and 8 of the National Household Survey done in Dakala shows that women spend 10 hours of their time doing unpaid care work. Your lordship, having done unpaid care work for 16 years, there is no way anyone can come out and say that she is indeed not deserving of a 50% share in this monetary property. Your lordship, may this court be bound by the decision in the Supreme Court case of Julius Rabinumi versus Hope Bahimbisomwe Civil Appeal number 10 of 2009, where a 50% share was granted to the respondent after valuing her contribution in their marriage. Your lordship and lordship, Article 31B is clear to the extent that men and women shall have equal rights at marriage, during, and at its dissolution. Your lordship, based on the aforementioned submissions.
Counsel Motes.
Yes, your lordship.
What did the appellant come with in the marriage?
Much obliged, your lordship. The appellant came with nothing, likewise the respondent.
What about the land?
The land was given to him as soon as he got married, and that's when they started tilling on it. Given to him to hold as a trustee of the Okoye family. Much obliged, your lordship. Your lordship, based on the aforementioned submissions, which you have read and heard in their full flavor, having it in mind that today the appellant Rita Izoma stands as a representation of many women in Dakala with only a primary school education, therefore cannot get into employment sector, with no inheritance from her family solely because she was born female, with no capital saved up to to start up her own business, literally having nothing to sustain her and have a livelihood. We therefore pray that when this court retires to deliberate on these matters, comes to a conclusion that, number one, the land trial judge erred in law and fact when he held that the appellant was not entitled to any share of the property on which her and the respondent's matrimonial home was situated. Number two, that the land trial judge erred in law and fact when he held that the appellant's non-monetary contributions only equated to 20%. Your Lordship, we further pray that the appellant is granted either half of the property on which her and the respondent's matrimonial home is situated or half of its monetary value. We therefore conclude this issue by saying that we pray that this honorable court overturns the decision of the High Court because it contravenes with the appellant's right to equality at marriage during its dissolution. Number two, that it contravenes with her right to property. And number three, it is discriminatory in nature. Much obliged.
Council Sandra, following your prayers, do the councils for the appellant have any proposals on how best the appellant court could calculate indirect contribution deriving from any authorities?
Much obliged, Your Lordship. I beg to re-echo your question. Are you asking whether, pardon me, the question?
Do councils for the appellant have any authorities that could guide this court on how best we could calculate the value of her indirect contribution?
Much obliged, Your Lordship. On that matter, Your Lordship, we pray that this court looks at the life situations, because it is clear that she slashed the house, that she mopped the house, she cooked the food, she did all the work for 16 years, remembering that she did this for 10 hours, Your Lordship, and receipts cannot be kept for the same. We therefore pray that this honorable court overturns the decision of the trial court and allow this appeal to stand.
Reference to the number of hours that she worked over the 16 years.
Further, we can also look at the GDP, where women contribute more than men.
Okay, thank you.
Much obliged, Your Lordship.
If it may please this honorable court, my name is Akankwasa Isabel, together with my co-counsels, Miss Evelyn Semeri and Mr. Ejai Gabriel. We are counsel for the respondent, Mr. Robert Okoye. We shall take up 30 minutes of this honorable court's time, and I'll take up 11 minutes handling issue 1 and the matter of jurisdiction. It is true that there has been a historical gender imbalance. It is also true that in the Republic of Dakala, there has been discrimination on women and inequality. This is actually in our facts. But we would like to bring to notice this honorable court that the facts before us differ. This is an appeal court. This is an appeal case that is before this honorable court because the appellant was not satisfied with the trial court's decision. To handle jurisdiction, the respondents do not seek to oppose the jurisdiction of this honorable court, as it's reinstated in Rule 30 of the Judicature Court of Appeal Procedure Rules and Article 134, Clause 2 of the Constitution. However, we would like to first of all discuss that the appellants raise the fact of constitutionality. This is a court of appeal, my dear Lord, my lords, and court of appeal is given that duty under Article 134, Clause 2. Constitutional matters are then handled in the Constitutional Court under 137, and the case of Uganda Association of Female Lawyers versus Attorney General, the 2003 case, clearly tells us the duties of the Constitutional Court. The matter before us is not a constitutional interpretation matter, so So the appellants asserting that it's a constitutional matter is a grave infringement and therefore takes away the jurisdiction of this court and then refers the matter to the constitutional case. In the alternative, we would like to then respond to the arguments raised by the appellants. They discuss matrimonial property, but not to the test in the facts before us. Matrimonial property, as in Bahimbisomwe versus Rabinomi, is a three-part test. And Bahimbisomwe versus Rabinomi also quotes Chintu versus Chintu, a 1997 civil appeal case. That gives us a three-part test. The three-part test is that it can be held in trust for the clan, that the land is actually what the parties choose to call home, and they jointly contribute to it. This was not done by the respondents. However, on that matter, we would actually also...
Council, are you sure that's a three-part test, or those are the options of what can constitute a matrimonial home?
Much obliged.
Which one is it?
Much obliged, my lord. I actually beg to submit that this is what the court considers as matrimonial property. So that would actually amount to what the court considers as alternatively inferred that it was a must for it to consider.
So you must meet all the three requirements?
Yes, my lord, it's a cumulative test.
Okay.
Much obliged. Customary law and the duty of the matter before us is of customary tenure. The respondents did not actually, the appellants did not actually address this matter, the matter in the honorable court. When you look at paragraph 3 of the facts, the matter before us was held by the ancestors, is an ancestral land of the respondent. The appellants are set to ask for 50%. It is actually true that the appellant has economic rights. She has land rights. The matter before this honorable court is looking at customary land vis-a-vis the rights of the vulnerable. The appellant is actually vulnerable and she's entitled to these rights. That is why the trial court, despite the land actually accumulating to customary land, I would like to refer to this honorable court to Serak versus Nigeria. This is an African Commission decision that actually lays down what customary land is and the rights of the people of a community. So the fact that actually the land in question is customary land, court looks at this and despite that gives her a 20% of this land because she has actually duly contributed. The respondents do not seek...
Council, please repeat that principle in that decision.
Much obliged, my lord. The principle in Serak versus Nigeria is to the effect that the people also have rights. The people as a collective. Generally, the case talks about the Ogoni people of Nigeria. So the collective people of Nigeria had their rights and they must be upheld. However, the court said that in the enjoyment of their rights, they must not infringe on the individual rights or the rights of the marginalized. I would like to refer this to the facts in instant that actually court did not infringe on her rights. The cumulative test of discrimination and inequality has actually been met and therefore I beg your pardon, the cumulative test that is laid down by the United Nations in the normative content on the right of equality and non-discrimination has not been met in the appellant's case. The cumulative test is full participation, inclusion, and consideration of differential decisions. The trial court, when we look at paragraph 17, yes, the respondent actually asserts that it was just a matrimonial role. But the trial court's decision, the reason we are before this honorable court, the trial judge takes in cognizance that this is customary land. However, the appellant has rights to it. There is full participation. She is included in the laws when you look at the Republic of Dakala, and there is also differential decisions. That the decisions differ from the customs. When you look at paragraph 9 and 10 of the matters before us, and also, pardon me, my lord, when you look at paragraph 12 in the matter before us, we look at the fact that the Tonga customs do not actually give women any rights, but the trial court's decision seeks to actually gives her rights. It gives her 20% of the value of this customary land. So therefore, the appellant's assertion that she deserves 50% has actually not been met. Your test of discrimination was not duly addressed. What is the test of discrimination? The United Nations and the declaration on the African and human rights, the preamble and the general comments are all to the effect of the test of inequality and discrimination. The truth is that in Dakala it is present, but in the trial court's decision and coming to a cumulative test of 20%, he does give her due cognizance and look at her contribution, and then comes to in the matter before us. In paragraph 17 and 18, he also takes cognizance of international law. The state has the obligation to protect women, and the state also has the obligation to protect customs. The matter before this honorable court is for the court to lay down precedents on how customary law will be met vis-a-vis how the women's right in the Republic of Dakala. The trial court the respondents assert that the trial court meets this test in its decision of awarding her 20%. The appellants also seek to assert the concept of quid plantatio. However, this concept is in the sale of property when we are considering chattels. It's not a matter of customary land. When we go back to section 27 of the Land Act that talks about the Land Act that was quoted, that talks about the infringement of women, it's actually section 22 of the Land Act of the Republic of Dakala that is to that effect, that discusses that in the enjoyment of rights of the custom and customary rights, women and the vulnerable, inter alia the disabled, must not be infringed upon. We would like to look at the rights of the Okoye people. When you look at the rights of the indigenous people, would like to refer to this honorable court to the International Labour Convention 169 of the indigenous people that discusses the rights of the indigenous people. The rights of the indigenous people must be upheld, and that was actually true in the trial court's decision, but also the rights of the users of that same land. The rights of the user, who is the user right in the matter before us, the appellant, and the respondent. In the alternative, when we look at...
Counsel, could you point us to the paragraph in the facts that qualifies the Okoye people as indigenous people?
Much obliged, my lord. The indigenous people is also... The Okoye people qualify as indigenous people because of the last line in paragraph 9 that says, property has no title and therefore is ancestral land of the Roberts family. When we look at the case of Atonya versus Okeny, a civil appeal case number 51 of 2017, it gives us that inter alia, indigenous people and also the people and the customs shall follow a lineage, which is true to our facts.
Do you have an authority? Could you define for us what indigenous people are as defined by the convention you just cited?
Much obliged, my lord. Indigenous people are people that they seek to identify themselves as a whole. 2, they have customs in which they all follow. And thirdly, the customary nature of their land is binding to them and the people of it. This is also discussed in the International Convention, and it is true. Pardon me, my lord. This is also discussed in the International Convention and in the International Convention of the rights of the indigenous. However, I would also, and the African Commission of Human and People's Rights, the comment on indigenous people 28 that was discussed in Benin in 2008, that discusses that the test of customary land and the user factory rights. I would like to refer to this honorable court to Article 45 of the Constitution and Article 27 to Article 45 of the Constitution, 43, pardon me, please, and Article 27(2) of the African Charter on People and Human Rights, that in the enjoyment of one individual rights, there should be due consideration on the bundle rights on it. The land in question has bundle rights, and the land in question must also consider the vulnerable person right now who is the appellant. The trial court's decision weighed both of these issues and came to a decision that actually she deserves 20% looking at the market value. Conclusively, I realize that my time is fast spent, so conclusively, we pray to this honorable court that 1, the matter will be dismissed on grounds that the respondents raise constitutional matters, and this is a court of appeal, and therefore does not have jurisdiction to hear the matter. as in Article 134 vis-a-vis Article 137 of the Constitution, and secondly, that the question in property, that the trial court's decision to grant her 20% duly considered the usufructory rights of the appellant and the respondent vis-a-vis her contribution and vis-a-vis the community and boundary rights before it. If I'm of no further indulgence to this court, I beg to cede the floor to the next speaker. Much obliged.
May it please this Honorable Court, Semere Evelyn Angela for the respondent, Robert Okoye. In 7 minutes, I'll address this Honorable Court on issue 2. The respondent recognizes that Dakala's history is characterized by gender disparities with regard to the distribution of matrimonial property, especially at the dissolution of marriages. However, we stand here to defend the trial court's equitable distribution of the property in question. My Lordships, under issue 2, counsel for the appellant avers that the trial court in its decision to award the appellant 20% of the value of the property on which the matrimonial home was situated is a violation of her rights to equality during and upon the dissolution of the marriage, and her rights to property under the Constitution of Dakala. And we stand here to refute that claim because the trial court, in fact, upheld these very rights in making its decision to award the appellant 20% of the value of this property. The trial court, which we seek to challenge the appellant's aversion in twofold. The trial court only sought to apply an objective standard to the division of the property in question, taking into consideration that this property is not owned by the parties, first of all, but it is property that belongs to the property that belongs to the Tonga tribe, to the Okoye family under the Tonga tribe, and that the appellant and the respondent only came to this property after the effecting of their marriage and had rights to use the property. Section 101 of the Evidence Act of the Republic of Dakala lays out that the burden of proof of a party that asserts a particular fact lies on that party to prove it. Your Lordships, the appellant avers that she is entitled to 50% of the value of the property on which the matrimonial home was situated, but the trial court, to establish that indeed her contribution to this property was 50% of that value, needed to have an objective standard to base its assessment and arrive to the decision that indeed her contribution was 50%. Even when the trial court realized and acknowledged...
Counsel Evelyn.
Yes, Your Lordship.
Even before you indulge us in the contribution, I would want you to re-echo what your argument is vis-a-vis, your argument is on user rights, vis-a-vis allowing this couple to build a permanent house on this land where they had user rights.
No, Your Lordship, that has been addressed by the previous speaker. My argument is based on the fact that the trial court, in requiring documentary evidence for the appellant to prove her contribution to the property, was only the trial court applying an objective standard to establish that indeed her contribution was 50% of the value of this property. Your Lordships, may it please, Honorable Court, I seek to continue.
No, I want to hear, maybe I didn't hear her say it. I want to hear from you. Could you address this court user rights vis-a-vis that permanent house that this couple put on that piece of land?
Much obliged, Your Lordships. User rights are explained in the case of user rights on customary land are explained in the case of Auma Lucy versus Kidega Moses. That these user rights are just rights; they are not ownership rights over this land. But it meant that, owing to the fact that the respondent had this land in trust for the Okoye family, he could use that land to develop it as he pleased. Much obliged, Your Lordships.
So, Evelyn,
yes, sir.
Did the councils address themselves to the doctrine of proprietary estoppel?
I beg your pardon, Your Lordship, Council.
Basing on Her Worship's question, did the councils address themselves to the doctrine of proprietary estoppel and how equitable interests arise on property?
Yes, Your Lordships.
Could you tell us how?
Your Lordships, proprietary estoppel stems from the beg your pardon?
Because you seem to aver that they both have user rights.
The
Yes.
appellant and the respondent.
Yes.
Your Lordship, they...
Take a minute, maybe Council Isabella could address the court on that. Just a minute. Council Evelyn, let Council Isabella take that question.
Much obliged.
Much obliged, my lord. When we look at Oma Lucy versus Chidega Moses, the case is to the effect that Justice Mubiri discusses customary land in depth. He also discusses the rights of the people on it. Remember that in customs, the economy is largely informal, and therefore, there is no, the people there do not have it in them. A layman will not say, oh, this is land by my father. He lived there, and therefore it moved on. Justice Mubiri, in the same case, laid down for us the test of usufructory rights, and therefore the question on proprietary estoppel is valid. However, it's a court of appeal case.
This is a court of appeal decision. This is a court of appeal that you're talking, and
Yes.
you're raising a high court decision.
Yes, my
Am
lord.
I bound by that decision?
No, my lord, I pray that you're only persuaded by it. However, to just simply explain the case, he raises for us the concept of usufructory rights. To actually establish proprietary estoppel, it's the concept and the extent that in customary land, one cannot deeply appreciate the value, cannot deeply appreciate their rights, equitable or ownership. However, when you look at the African Commission on or the general comment on the same of the indigenous people, it's clear that in day-to-day life, people do not actually know that they don't have ownership rights on this land because their fathers have owned it before and therefore could construct a house, as you had actually said.
Council, what
Yes,
their
my lord.
lordships are asking is, do you not think it legally unfounded for you to have had the right as to build, to have all this, but now during the sustenance of the marriage,
Yes,
but now
my
when it
lord.
comes at the dissolution,
Yes.
you're denying ownership and saying you only had user right. I think that's the gist of their question.
Yes, my lord, I see where the conflict arises there. The conflict then becomes that we are now arguing the fact that during the marriage, they seemed to impute an ownership of the land, and at the dissolution of the marriage, they seem to actually abandon and say, no, actually, this land is not mine, and therefore, the land belongs to the people, and we cannot use it.
So did the appellant actually rely on that assurance that she had some form of interest before she contributed?
Much obliged, my lord. I don't think that the appellant in her mind at the time of the marriage could actually address herself to the point that, one, she could divorce her spouse, and secondly, the depth of the rights.
So she contributed to building a home on land that belonged to no one?
She contributed, much obliged, my lord, she contributed to building a home on the land that belonged to her husband's tribe, her family, her in-laws. That's what she contributed to.
That's your assertion?
Yes, it's
Okay.
also, it's
You
not
may
only my
proceed.
assertion, it's, much obliged, my lord, it's not only my assertion, but it's also to the facts. When you look at paragraph 9 of the facts and paragraph 10, the joint contribution does raise that question, but we do feel as the respondent that 20% of this same property was enough, considering her contribution, considering the bundle rights on the same land, and duly considering what she had done during the marriage. Much obliged.
Yes, Council Evelyn, thank you very much, Council Isabella.
Much obliged, Your Excellencies. Now that my co-counsel has addressed that point, I seek to emphasize summarily that the trial court only emphasized the need for documentary evidence to prove that indeed the contribution of the appellant was 50%. Your Lordships, courts cannot divert from elements of procedure simply because rights have been violated. imagine the circumstance if we had established earlier that this court had no jurisdiction to hear the case, even if we acknowledge that rights had been violated, this court would still not hear the matter. In the circumstances, Your Lordships, that the appellant avers that the trial court's demand for documentary evidence is premised on violation of the appellant's rights, but we refute this, and we see that in the facts on page on page 8, paragraph 19. The High Court judge took cognizance of the fact that unpaid care work is considered part of non-monetary contribution when making decisions on distribution of matrimonial property, and he stated that in line with the obligation of the Republic of Dakala to promote rights of women, as espoused in the CEDAW, Maputo Protocol, and the Constitution of the Republic of Dakala, he based on these rights, the appellant's rights given to her in the Constitution and international law, and assessed her non-monetary contribution basing on the availability of the same services on the local market. Your Lordships, this yardstick was also laid down in the case of Ambayo versus Aserowa, where they stated that even when it is in circumstances where it is impossible to produce evidence or records or accounts to prove actual contribution to property, then courts are implored to apply that standard, measure the same yardstick. Much obliged, Your Lordships. Much obliged.
So Evelyn, sorry about that, Councillor Gabriel.
Councillor Evelyn, can you guide this court? Did the respondents, while at the trial court, actually provide documentary evidence of your monetary contribution to this property? We still not to have that on record.
No, Your Lordships, but the respondent does not aver that he does not aver that he is entitled to 50% of the value of the property. This evidence was required of the appellant for her to prove that she is in fact entitled to 50% of the value of the property. The standard has been laid down in in section 101 of the Evidence Act, that he who alleges must prove. The appellant alleges that she is entitled to 50%, and so the trial court demanded for evidence for her to prove that actual 50%. And even without that evidence, and the trial court acknowledged that fact, that the evidence was practically impossible to produce, the trial judge had cognizance of her rights under the Constitution and international instruments, and awarded her accordingly by applying an objective standard still that was laid down in the case of Ambayo versus Aserowa, and assessed her contribution basing on the availability of the same services on the local market, and came to the conclusion within its discretion that 20% was an equitable result.
Councillor Evelyn, in just 1 minute before you take leave, could you also address this court on the issue that was raised by the appellants on discrimination in light of the international instruments you've cited and the Constitution of Dakala, especially as it regards to culture and customs?
Much obliged, Your Lordships. The respondent acknowledges the fact that Dakala and Africa are characterized by discrimination of women, which manifests in form of a disregard for their non-monetary contribution to matrimonial property, especially at the dissolution of marriages. But under these statutes, under these international instruments, states have an obligation to protect, fulfill, to protect, fulfill, I beg your pardon, Your Lordships. States have an obligation to protect, to fulfill, I beg your pardon, to respect human rights, and in the course of attaining their realization. By recognizing in paragraph 19 that the appellant has rights as a woman and she cannot walk away with nothing upon the dissolution of the marriage, the trial court fulfilled its obligation to protect and fulfill and respect her right to property, and it awarded her accordingly. But they insisted on applying an objective an objective standard to this. With regard to customary property, did you seek?
With regard to custom, the Tonga clan that she cannot inherit land from her mother's side, and then also she cannot have property rights from her marriage.
Much obliged, your lordship. The trial judge, even with that custom that bars women from owning property during marriage and also from where they are born, the trial judge looked away from this very custom and recognized and upheld the supremacy of the Constitutional Republic of Dakala and the state obligation entailed in the international instruments, and came to a conclusion that she is entitled to a portion of the property within his discretion. And he applied an objective standard, as we emphasize, and he assessed this contribution and came with 20% as an equitable value. Much obliged, Your Lordship.
May it please this Honorable Court, Gabriel Ejai Opolot, appearing on behalf of the respondent in the instant case. I shall take up 12 minutes of this Honorable Court's time in directly responding to the council's opposing council's statements and handling substantive issues 3 and 4. First, in direct response to 2 of the opposing council's statements, council quoted wrong law. Council mentioned Ambayo Jackson, 2 of them. But I'd like to put this court's attention. The case is Ambayo Joseph versus Aserwa Jacqueline. In quoting wrong law, they are persuading court on wrong law on cases that do not exist. Secondly, counsel for the appellant mentions that the trial court did not, it was my land friend Mwine Andrew, that the courts did not value the appellant's non-monetary contribution, that the trial court did not value. However, we can see that the trial court did value the non-monetary contribution, and I shall get into that in the substance of issue 3. And thirdly, the counsel for the appellant mentions that the appellant worked for 10 hours or more on the property. However, counsel for the appellant should have mentioned that this was their opinion and that in the facts of the case, this is not mentioned. This was just a national household survey of 2022, and it was given an estimate. Counsel directly mentioning that this was the appellant's contribution is trying to draw the bar's attention and persuade the bar in facts which are not established. This is just an opinion which counsel should have mentioned. And last, counsel, as stated by my previous co-counsel for the respondent, counsel for the appellant keeps mentioning that this honorable court, that the issue in question is infringing rights granted in the Constitution, but counsel for the respondent will stand on our claim that any matters of constitutional interpretation, and this was mentioned by my land friend Faith, any matters for constitutional interpretation fall back to the court, to the Constitutional Court, which is not the current court sitting here, as established in Articles 134 and 137 of the Constitution of the Republic of Dakala. Proceeding to substantial issues 3 and 4. The issue that was the trial court's valuation of the appellant's non-monetary contribution at 20% rather than 50% infringes the right. However, counsel for the appellant states and asserts that the trial court took this in due cognizance and recognized her monetary contribution, and I shall handle this under a head of argument that there was a due recognition of these rights and of her contribution to this property, and that the trial court reached a due valuation based off the facts of the instant case. The respondent does not seek to contend and contest that the appellant did contribution to the home. In fact, he does allow, but the distinction is the valuation of the non-monetary contribution that was arrived by the trial court did not infringe his rights, and I shall discuss this because commonly, it's accepted that to prove something, you must, to determine contribution of spouses on property, it must be done on a basis of facts, taking in nature the peculiar facts of each case. This position was stated in the Ambayo Joseph case versus Aserua Jacqueline, and it was also stated in PNN versus ZWN. All these cases are only persuasive to this honorable court, and it is up to its discretion to consider them or not, but it's just for persuasion. In the PNN case, it was held inter alia that it was a Kenyan Court of Appeal case, Civil Appeal 128 of 2014 on pages 16 to 17, where the judge held inter alia that contribution of spouses as per Article 45, which the Council for Appellant vehemently states, and that refers back to our Article 31 of the Constitution of the Republic of Dakala, this does not give a 50-50 valuation of property. Courts should reach their decision based off the peculiar facts of each case. And we can see in the facts of this case, on page 11 of the facts, on paragraph 11 of the facts, however, that even when the appellant seeks to say that this property, she worked on it alone, and that she worked on the farm, the respondent reminds this court that they worked on this farm together. They did the work together. The appellant did the work also with farmhands, paid for by the respondent. But thirdly, the respondent himself also did this work. Back at home, taking in cognizance the work that the appellant did, the trial court reached its valuation basing on the facts and the peculiar facts of the case. Usually, division of matrimonial property is done considering principles of equity, that we are not going to look at just 50-50. You have to look at what was done. And what was done, these parties to the case, they did the work and had a distribution of how they had their monies spent. In this case, we see the respondent, Mr. Robert Okoye, had an 80% valuation after all the valuation because, again, paragraph 11 of the case, which is page 5, on line 13, which is the last 3 lines of the paragraph, that he, among others, would pay school fees for not 1, not 2, not 3, but 4 children. He purchased seeds and materials.
Councillor Gabriel.
Purchased seeds, yes.
Indulge me on that, expound on that more. Where was he getting this money from?
Much obliged, Your Lordship. This money was got from the work that they both did on the farm.
So it was joint. The lady was also contributing.
Yes, she was. And that's why, much obliged, Your Lordship, she did contribute to this. And the reason he got the 80% was because he had heavy tasks to pursue and to do. Yes, they both contributed, but he bought seeds. He bought machinery. He did paying the farmhands, purchasing materials, paying fees for school.
Is it fair in your assessment that both of them worked on the land and he took 80% of the proceeds and Rita took 20%?
Your Lordship, the respondent does not say that the 80-20 was, it was not in, it was done in due consideration of the way the parties handled the income they used to do the work done.
So no, you can't come here and tell us that he paid school fees, he did this. The lady was also contributing to doing that because she also gave in labor.
Much obliged, Your Lordship. Yes, she did give in labor. The respondent in this instant case is asserting that the trial court did take in cognizance all of this. The trial judge recognized all of these facts and reached a decision basing on the facts of the case. In the
You seem to still be averring that the respondent made some form of physical contribution in terms of labor to the vanilla garden. And I don't see that in paragraph 11. I think I've read it about 3 times from when you kept mentioning it.
Much obliged, Your Lordship.
So you're misleading the court?
No. I am mentioning that he did work on the farm.
How?
How?
Please point us to the particular paragraph where that is mentioned.
Yeah, much obliged, Your Lordship. Paragraph 11, line 1.
Yes, please read it verbatim.
Verbatim. Rita used to till the land with other farm hands that Robert employed to assist her, together with Robert.
Are you sure?
Continue.
Together with Robert, they managed the process of harvesting the vanilla and sold it. Then 80% of the proceeds would continue, and the paragraph continues on and on.
Is it true that Robert only came in at the time of harvesting, but during the tillage and
He did come in time of harvesting, Your Lordships, but he also contributed to this because he paid the people who helped the appellant with this same valuation of the money that they decided on how they distributed.
How did he get the money to pay?
From the vanilla farm, Your Lordships.
Counsel, maybe you could read paragraph 10. It could help you better. Paragraph 11 isn't good for you.
Yes, Your Lordship. I read paragraph 10 verbatim. When they first moved onto the property, there was an old small room, 2-house house, and the land was filled with bushes. Within a year of living, they had cleared the land.
They?
Yes, they. Your Lord,
That's a much better argument than the one where he comes in at harvesting time.
and takes 80%.
much obliged, Your Lordship. The whole 80% was brought to introduce to this court's attention the reason as to why the appellant, the respondent, still gets this valuation, taking in also due cognizance the whole thing of maintenance. Maintenance is seen in Section 5 of the Children's Act to include, amongst others, education, immunization, adequate diet, clothing, shelter, medical attention, and the trial court judge had given this maintenance only and only to the respondent. They, however, did have joint custody, but maintenance was done by the respondent alone on top of the other tasks he did. The respondent still avers that courts should take in cognizance peculiar facts of each case in determining contribution of spouses, and that the trial court judge took this in cognizance. He recognized the rights and the value of the work done and reached a valuation basing off this, as stated in Ambayo Joseph versus Aserewa Jacqueline. Moving on to issue 4, the respondent prays that this honorable court dismisses this suit and the appeal dismissed, basing off the grounds that this court has the jurisdiction to grant the relief sought under sections 10 and 11 of the Judicature Act, Article 134 of the Constitution, sections 10 and 11 of the Judicature Act, Rule 30 of the Court of Appeal Rules, and Father Nasensio Begumisa versus Eric Tibebaga, and prays thus that the property in question is deemed customarily owned land, that the trial court judge's decision to use documentary evidence was only to establish a reasonable standard case and reach the basis of the facts.
So, Gabriel, your time is up.
I realize my time is fast spent, Your Lordships. I beg for 30 seconds to finish my last 2 prayers.
I'll be generous and give you 1 minute.
Much obliged, Your Lordship. Thank you. The respondent prays that this property was deemed customarily owned land. That secondly, that the trial court judge's decision to require documentary evidence was only to establish a reasonable standard. But even without the documentary evidence, He thus valued the appellant's contribution, basing off on what they had. Third, that the non-monetary contribution of the appellant does not amount to 50% as stated in the issue. And last, that the costs of this suit are bared by both parties. If I'm of no further indulgence, I beg to cede the floor.
Much obliged, Your Lordship. I would like to confirm if I'm audible. Yes, fast forward, I don't think it's procedurally right for the respondents to do a rejoinder where they're supposed to make their respondent submissions. And I just got shocked because even court didn't indulge, so I pray court really finds that not really procedurally right, because the rebuttal is essentially supposed to be done by the respondent. What they're supposed to do is what is known as a surrebuttal. Fast forward, counsel stated that this court doesn't have jurisdiction.
Counsel, procedurally, the respondents have a duty to respond to the submissions that you've made. Even practically, you serve them what you have submitted, and they respond to your own submissions. They did not come to this court. You, the appellant, came here. So it was not a surrebuttal or anything. They were responding to what brought you to this court.
Much obliged, Your Lordship. In regards to the rejoinder, counsel stated that the court doesn't have jurisdiction to handle this appeal, and it should be referred to the Constitutional Court. Your Lordship, it is clear that the Constitutional Court can only handle matters as arise out of constitutional interpretation. The matter at hand is arising out of a divorce cause, and also in particular that the decision was infringing on the rights of the appellant, Your Lordship. And Section 10 is clear that the court has powers to handle any decision arising out of this decision. The matter before you, Your Lordship, I don't remember arguing anything in regards to any articles being inconsistent to each other. The argument here is premised on the fact that the respondent or the decision that the trial court arrived at was not fair and was infringing on the appellant's rights, which this court has jurisdiction to handle. Secondly, in regards to matrimonial property, counsel states that the threshold test provided for in Ambayo is a threshold test, which is quite not really clear, because, Your Lordship, if you to give this definition by Bossa J, which was later adopted in Rabinumi versus Bahimbi Sowe, Supreme Court Civil Appeal number 10 of 2009, it is clear to the extent that each property shall be treated differently. What that means is that this property can accrue in different contexts. In one context, you may find this land owned by the clan. In the other context, you may find this land owned by the individual themselves. In the other context, you may find that actually that land is owned by two parties. Therefore, any of them could accrue, and this test, giving it a literal interpretation, does not mean that all these elements have to be available for it to amount to matrimonial property. Secondly, counsel cited the case of Sarek versus Nigeria, which actually she agreed to the fact that communal rights are user rights, which same rights can be accorded to the appellant. She also cited the test of discrimination, and she cited an international provision. However, we have the statutory provision, which is clear to the extent under Article 21, Clause 3 of the Constitution of Dakala, which in any way has to take priority over international laws. And I pray that this Honorable Court finds it persuasive and be bound by the provision that discrimination can only be explained under Article 21.3. Secondly, counsel, the second respondent counsel provided for the objective test.
Counsel Faith, your time is up.
I pray for a minute.
You have a minute.
The case said that it should be on a reasonable test. Reasonability is a test of what any ordinary man would do. If this ordinary man, in case the trial judge, was reasonable, how could he or she then require documentary evidence where the appellant was providing non-monetary work? Evidence of cooking, evidence of washing clothes, that wouldn't be logical, Your Lordship. Secondly, Counsel Gabriel stated that one of us here stated the case of Ambayo wrongly, which we later asked a pardon from this Honorable Court. And Article 1262E is clear that justice shall be awarded without regard to undue technicalities. The other one is 80%. He clearly stated that we concocted facts. We didn't actually concoct facts. Counsel, if you are alive to the fact that paragraph 6 provides that they spend 10 hours, we did not concoct that. If you look at paragraph 6, page 3, it is clear statistics that were made and were provided in the hypothetical case. Therefore, counsel also considered to the jurisdiction of this court in his final submissions when he stated the court has right to give relief. Which court would have a right to give relief if it doesn't have a right to hear the matter? Your Lordship, the prayers are very clear. For the justice to be given, and
Counsel, your 1 minute is up.
we pray that this appeal is allowed and the decision of the trial court is overturned. We beg
Counsel
to
Faith,
submit.
before you sit down, is this court seated as a constitutional court today?
No, it is sitting as a court of appeal.
What were your initial statements that you made in regard to jurisdiction in rebuttal to them?
It is clear that this court is granted powers under Article 134 of the Constitution and Section 10 to handle matters arising out of the decisions of the High Court. That is why we are here. The decision was
As a court of appeal,
Yes, as the court of appeal.
not a constitutional court.
Not as a constitutional court.
Counsel, also just 1 minute before you take leave, you did allude to paragraph 6 as explanation for the working of 10 hours. Are those statistics a national representation of the state of Dakala, or they are a true testament, as I want to believe you submit, of what was happening between Rita and Robert? Could those now be used to mean that Rita also worked 10 hours?
Yes, Your Lordship, because if you look at paragraph 6, I beg to read it verbatim. It says that the 2022 National Household Survey indicates that on average, female members of a household in Dakala, and Miss Izoma is in Dakala, which means these statistics are peculiar and are meticulous to the state in which Miss Izoma is in right now. Your Lordships.
She depicts every woman in Dakala. This is an entitled lady. So many helping hands.
Your Lordship, she's among the few. She's among the few because if you look at statistics, again, as I'll allude to those facts, Your Lordship, facts, paragraph 3, it provides that according to the most recent National Demographic Survey report, and it goes to the details providing of those women who hold property, those that have the power to make decisions, and how life and substance in Dakala is granted, or how women enjoy their rights in regards to property and also having decisions in that land. However, Rita Izoma, that is why we are here, Your Lordship, is among the few voiceless people, or the ladies in Dakala as a state, who provide non-monetary contribution, and at the end of dissolution of marriage, they are not accorded their share on the basis of failure to provide evidence, which are actually stringent measures, and the trial court indeed was erroneous to arriving at such decisions. And it is the prayer of the appellant that this honorable court desires and deliberates on the facts that indeed were adduced and the evidence to reconsider, and because it has a duty to uphold and under affirmative action to protect such women that like Rita Izoma, that this court shall award justice to Rita Izoma and overturn the decisions of the High Court and allow this appeal to stand.
Counsel, lastly, isn't it an antithesis to your submission that on one hand, you ask this court to treat every fact on its own, peculiar facts as the case is, and then on the other, you're furnishing this court with generalized statistics under paragraph 6. What should court consider?
The duty of this honorable court is to first of all appraise the evidence that was given in the High Court, Your Lordship, which we have been clear too that the High Court required documentary evidence, which was a stringent measure. Statistics are only able to guide court, but it has to exercise its powers as granted under the Constitution to find it fit, but most importantly to award justice to the marginalized women just like Rita Izoma, and that they should also advocate for a law reform. Because, Your Lordship, the reason that's why we are here is because our Divorce Act does not provide for measures, because our Marriage Act does not provide any metric. Otherwise, courts wouldn't even be wasting time. It would be clear. So it is the duty of this honorable court that if it can overturn the decision of the High Court, maybe even the Parliament will be moved to draft better laws that protect both the males and females in, during, under the dissolution of marriage. Your Lordship, we beg to submit.
All right.
Thank you. Thank you for. Good afternoon. The court is adjourned. Then we can leave. Thank you.
the boss. Michael, Jose. Single ladies. Chuba. Zambula, my sunshine. For my life, you day shine. With you, I go day fine. You be my love divine. Every night you dare my dream. You be my sweet ice cream. With your life, not sweet thing. You the sweet like sugar, thing now you. I go love to the end of time. Now you, I go cherish like vintage wine. With you, the paradise I define. Forever and always you'll be mine. Your love that make me fly. You're strong enough now.
DJ Lens.
Tell me what am I supposed to do? Sit around and wait for you. Well, I can't do that. There's no turning back. I need time to move on. I need love to be strong. But I've got time to think it through. Maybe I'm too good for you. Oh, do you believe in love from love? I can feel something inside to say. Really don't think it's strong enough. Nature's harmony so sweet. With every drum we heart skip beat. Moonful sky they smile. We they groove across the mile. Now moonlight dance. We they flute they play. Our heart they sway. On the moon we they feel the breeze. Sweet melodies from head to feet. Mama, Rokaya shine no lugolo. Èmi àtẹ̀bí náà wà pẹ̀lú ra. Katikati ya nyota, usiku tulivu na sauti. Roho inapata amani. Ngoma hutuleta pamoja. Tunapita pole pole. Mandhari ya kijani kibichi. Moyo unajaa furaha. Flute ikilia tamu. Mfalme wa usiku. Roho yangu itaimba. Ngoma zetu tuzameni. Maisha yenye amani. Mwanga wa mwezi wa dhahabu unanielekeza njia. Amani inatiririka moyoni. Ndoto zinapata uzima. Upepo wa asubuhi kama kunguru hewani. Tunacheza na kuimba. Milima na mabonde. Mfalme wa usiku. Roho yangu itaimba. Ngoma zetu tuzameni. Maisha yenye amani. kati ya nyota, usiku tulivu na sauti, roho inapata amani, ngoma hutuleta pamoja. Mto unapita pole pole, mandhari ya kijani kibichi, moyo unajaa furaha, fluti ikilia tamu. Mfalme wa usiku, roho yangu itaimba. Ngoma zetu tusameni, maisha yenye amani. Mwanga wa mwezi wa dhahabu unanielekeza njia, amani inatirika moyoni, ndoto zinapata uzima. Upepo wa asubuhi kama kunguru hewani, tunacheza na kuimba, milima na mabonde. Mfalme wa usiku, roho yangu itaimba. Ngoma zetu tusameni, maisha yenye amani. Upepo wa asubuhi kama kunguru hewani, tunacheza na kuimba, milima na mabonde. Mfalme wa usiku, roho yangu itaimba. Ngoma zetu tusameni, maisha yenye amani. Maisha yenye amani. machukumele kaijide kanura utoni homa ngozi nuwatu kamira hunezo kobi daima ebene bani gebili kona panututu aigato to nebu di bojo kifeni legaga mudonobi ikwe kebu bifani naya oh 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 benile ebene benkechi nkana bakalike kedu makahuike ona makobike mwa ebene benkechi nkana bakalike kedu makahuike ona makobike mwa ebene banyiga buba ngobi odiga dudo mo nebu bebi no chichobi
Sky na shine, silent night they find. We they dance now for ground, feel the rhythm all around. Stars they wink for we, ocean breeze they cool we free. Move your body small, small, underneath the palm tree tall. Now moonlight dance, we day, flute they play, our heart they sway. On the moon we they feel the beat, sweet melodies from head to feet. Close your eyes and take my hand. Feel the groove across the sand. Flutes and drum they guide me way till the first light of the day. Nature's harmony so sweet. With every drum we heart skip beat. Moonful sky they smile, we did grow across the mile. Now moonlight dance, we day, flute they play, our heart they sway. On the moon we they feel the beat, sweet melodies from head to feet. Nature's heart